All right. Are we ready, Freddie? Good evening, everybody. The December 9th, 2025 Liquor Board hearing is now in session. I'm going to make a move here and request that we approve the transcript from the October 14th, 2025 board hearing as the official minutes. All the board hearings and transcripts are now stored electronically and serve as the official minutes. They can be retrieved online, and they can also, you can view them by making an appointment at the liquor board if you so desire. I'm looking for a second.
I'll second.
Okay, thank you, Commissioner. I have a second. All in favor?
Aye.
Very good. Mr. Hurdle, if you would, please.
Thank you, Mr. Chairman. I'm Abraham Hurdle, counsel to the board. At the beginning of every meeting, counsel makes a few brief announcements. First, the commissioners are part-time public servants and they have other outside interests. When they know they have a conflict of interest or the appearance of a conflict of interest, they recuse themselves. They cannot possibly know who will appear from the public in any given matter, which may present a conflict of interest to them. If anybody believes that any commissioner has a conflict of interest in any matter, you have to announce that to us as the case is called, and the commissioner or commissioners, as the case may be, will deal with that accordingly. If not, then the commissioners will proceed with all hearings under the assumption there is no conflict of interest. Secondly, the rules of the board provide that the chair, for the purpose of administrative and judicial economy, can have the board's counsel, myself, rule on the admissibility of evidence and objections if there are counsel present and objections made. The board handles many cases at every hearing, and this assignment allows us to expedite the hearings. So rather than the chairman turning to me and me advising the chairman, I'll simply make a ruling, and my ruling will be that of the chair. Mr.
Okay,
Chair?
very good. Thank you, sir. Chief, would you call the first case, please?
Thank you, Mr. Chairman. Welcome, everybody. As a reminder, please silence your cell phones. We also have one announcement before we announce the first case. Air Ventures LLC, trading as Martini, has been removed from tonight's agenda. That matter has been resolved administratively. That being said, our first case is for Silver Diner BWI. Thank you, Ms. Carter. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Please raise your right hand. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Starting from my left, please state your name and address for the record.
Yes, Glenn DeMore, name and 5101 Donovan Drive, Alexandria, Virginia, 22304.
Thank you.
Eric Forward, 9111 Robbins Preserve Drive, Cornelius, North Carolina, 28031.
My name is Adibo Algarin Acosta, 120 Liaison Court, Odenton, Maryland, 21113.
Thank you. Mr. Ertl.
Ms. Carter, as we discussed, the officer isn't here at the moment. We're going to add the report into the record and indicate that that is the report, and it stands as it's written.
Correct. Thank you, Mr. Hurdle. I appreciate that. Good evening, Mr. Chairman, members of the board. For the record, my name is Linda Carter, and I'm here tonight on behalf of Silver Diner at the BWI Thurgood Marshall Airport, Concourse B, Baltimore, Maryland. We're not happy to be here tonight. And as the board is aware, there are 5 charges. And with the board's permission, if I could kind of take them in reverse order, because I would like to address the issue that we view as being the most egregious, and that is the failure to cooperate.
Please go ahead.
I have had the privilege of working with Silver Diner for probably close to 20 years. And since 2010, statewide, I think we've had 4 incidents that have led to hearings before various boards in this state. Most of them involved sale to minor. And as I've discussed with the licensees, unfortunately, there is a limit to what we can do as licensees to prevent that from happening, although I do have an idea that I'm going to toss out to you later. But there is never an excuse for a manager, a licensee, or an employee to be rude or disrespectful to the police officers, health department officials, fire department officials, your inspectors. It's not something that I tolerate with my clients. It's not something you all tolerate. And in this instance tonight, it's really important for you all to understand it's not something that my clients tolerate. In preparing for this hearing, we communicated extensively, we meaning me and my clients, the licensees, communicated extensively about this particular issue. And if I could, I'd like to read to you an email that Glenn sent me on December the 4th at 6 o'clock at night, 6:09 at night. And this was in response to my email that was, this is absolutely the most important part, meaning this issue, because you don't tolerate it. And Glenn's response was, we most certainly do not tolerate the behavior the associate displayed. We are more than a company. We are a family. We care for each other, our guests, and the communities we live and serve. The way this bartender reacted is the antithesis of our culture. As Eric said, he was immediately terminated, as we will never condone that kind of behavior. Our carding policy is no matter how young or old, we card everyone. His violation of that policy and his attitude are why he is no longer part of the Silver Brands family. So, to put it all in context, that evening, he was immediately relieved from duty. Now, their process is to do an inspection, but an investigation to determine what the facts were. And the general manager attempted on several occasions to contact him. Never got a return call. So he was fired by email. It is not something, like I said, in all the years I've been working for Silver Diner, I have never had to defend them on this issue anywhere. And we're all apoplectic about this particular one, and we hope that the board will not impugn the bad actions of an employee who is no longer there on the licensees and the corporation as they appear before you tonight. We have been charged with what I understand is a failure to have a certified manager on the premises. We did actually have one. Michelle had sent a letter to the clients back, I believe, in July of 2025, and there were 4 managers at the time that were approved. And I am going to completely mess this name up. The gentleman has, his first name starts with an O, it's Olubukunola, maybe, and his last name is Ogunsilire. He goes by the name Bucky. Now, Bucky's not here tonight. Tito, who's mentioned in the report, is here. And Tito, if I were to call him as a witness, would testify that Bucky was, in fact, on the premises at the time that the incident occurred. And it's referenced in the police report. He was there, but the full name was not given. So I think that dispenses of that one. Unfortunately, the first 2 charges, we don't have a defense. Our employee did not do what he was supposed to do. Not what this board requires, and quite frankly, not what my client requires. Everybody gets carded when they order a drink. This gentleman, Chad, just didn't do his job. There were individuals on the premises that were alcohol awareness certified. We have just completed, I talked with their administrative assistant this afternoon. We have just completed a program, and every single front house person at Silver Diner, a BWI, is now certified, without question. And we're implementing a policy whereby on a regular basis, Lamb's husband, in fact, will reach out to the managers to make sure that continues. because it was a gaffe, if you will, and we apologize for that. So, Mr. Chairman and members of the board, you know me, I can talk for hours, but I really think we've stated the facts as they need to be stated. Silver Diner takes its privilege of selling alcohol very seriously. We respect this board and the rules of the board and the laws of the state. We apologize for the incident, and that would be our case.
Mr. Chairman, any questions? Commissioners, any questions?
I have no questions.
No questions.
Okay, Ms. Carter, thank you very much. And I want to thank the licensees for coming in. I know, like all of these out there, this is not something you want to be doing this close to the holidays in the evening. Yeah, right. So I do want to thank everybody for that. And I do appreciate the fact that evidently Silver Diner took action or the appropriate steps for an employee who evidently you probably didn't want there anyway.
No, you're exactly right. You're exactly right.
So as they say, kudos to you for that. We don't encourage our licensees to terminate their employees, but at the same time, every case is an individual case, and some I'm sure deserve it, some perhaps not. So I do appreciate that. And as far as the alcohol awareness program, I'm going to dismiss that charge. That is the third charge, I believe, on the docket. We understand that, sometimes the information lacks a little bit or is a little behind, or we find out different. So I am going to dismiss the third charge. But I am going to make a motion to the board that we find you guilty, mainly due to an admission in this case, on the minors and serving someone under the age of 21. It's a very serious offense, and I'm sure you realize that. This board does. We take it very serious, but this is your first offense for this type. We take that into consideration. And normally we look back 5 years, and if we see anything with relative activity similar to that, then that we take into consideration, and it usually means the penalties or whatever would be more severe. But you've got 18 years of pretty much a spotless record, so we're going to take that into consideration. But I am going to find you guilty, or make a motion to find you guilty for both minors, which is the first charge, sale to someone under the age of 21, which is the second charge. On the the fourth and fifth charges, which is ownership, operation, and cooperation. The cooperation, I understand, was not on your part, but you are responsible for your employees. So I'm going to make a motion that I find you guilty on both of them. Because it's your first offense, I'm going to make a motion that we fine you $500 for the minor charge, $500 for the underage of 21 charge, and on the ownership and operation, $100. And on the cooperation, I'm going to make that a $200 motion. So we have 500, 500, 100, and 200. All right, total of $1,300. I'm looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye.
Aye. Thank you very much. Ms. Carter, thank you for everything. You gentlemen, lots of luck, and hopefully you take care of the storefront, so lots of luck.
Thank
Have a
you
good
so
night.
much.
Thank
Y'all
you.
have
Thank
a
you.
great evening and a fabulous holiday season.
Thank you.
Thank you.
All right, our next case is going to be for Harbor Liquors, 8140 Harbor Liquors LLC. Thank you, Mr. Lyman. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Please remain standing and raise your right hand. Or your right hand. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Starting from my left, please state your name and address for the record.
Agent Keith McGee, Maryland Alcohol, Tobacco, Cannabis Commission.
Good evening, Brian Lyman, Lyman, attorney for the licensee and her business, Harbor Liquors.
Vaishali Patel, 10509 Charing Court, Hanover, Maryland, 21076.
My name is Rajdeep Nayak, 602 Old Stage Road, Glen Burnie, Maryland.
Thank you. Mr. Hurdle?
Mr. Inspector?
Yes, sir. Yes, so on Wednesday, October 22nd, 2025, at approximately 11 a.m., I responded to Harbor Liquors located at 8140 Fort Smallwood Road, Curtis Bay, Maryland, 21226 for the purpose of a routine inspection of a business. Upon entering the location, I spoke with the clerk, Mr. Rajdeep Naik. Identified myself as an agent with the Alcohol, Tobacco, Cannabis Commission. I observed the trader's license, number 0230933, on the wall, and to be valid and properly licensed for the products they had for sale in the store. I then conducted a systematic inspection of all the cigarettes and OTP, other tobacco products displayed in the store. Mr. Naik produced invoices for the cigarettes, and on inspection, they all appeared to be valid Maryland tax stamps. Liquor license number 811, type A, BWL, was also on the wall, valid under the licensee defendant's name, Rashia Patel. Rashia Patel. I conducted a systematic inspection of the alcohol on the premise. During the inspection, I located 3 bottles of Blanton's Gold Edition Bourbon, 750 milliliters. Each bottle was dated individually. First bottle was dated for 9/11/24, second bottle 9/20/23, and third bottle was 10/5/23. Invoices provided to the agent did not match with the dates that were listed on the bottles. Mr. Naik advised those were the only invoices he had. I then spoke with the owner's husband, Mr. Patel, via phone on this day. He advised that there were the only invoices he had as well. Quick look on e-license shows that the business start date was 1/31/2024. Also conducted an investigation and spoke with a supervisor at Breakthrough who advised.
Objection. Move to strike hearsay.
Overruled.
Okay. Spoke with a supervisor at Breakthrough who also advised this agent that those products are usually within stores within 2 months of them receiving them from the distributor. Given that, I seized the liquor under AB 6311B1, purchasing, keeping an alcoholic beverage on licensed premise, which was purchased from other than a licensed wholesaler. AB 1408, records violation, and TG 5302, that unlawfully possess, buy, transport, sell, store, or allow other persons to buy, store, sell, or transport an alcoholic beverage upon which the tax provided by law has not been paid. Mr. Naik signed the confiscation receipt, and I seized the 3 bottles of Bland's Gold Edition Bourbon, submitted to the ATCC evidence room. This report will be forwarded to the Anne Arundel County Liquor Board for administrative hearing.
Mr. Lyman, do you have any questions?
Thank you. Agent McGee, was the clerk cooperative with you during the inspection?
Extremely.
About how long did the inspection take in aggregate?
It was actually an ongoing investigation. I'd been there prior to this, and I did respond back to follow up with this case.
All right, so you were actually investigating prior to the start date of your report, is that correct?
Yes, sir.
Okay, when did that investigation start?
A week prior.
Okay, and why is that not mentioned in your report?
Good question. Should have been put in there.
Okay, you don't have any specific reason why you did not state when the investigation actually began?
No, sir.
Okay. Did you bring the bottles with you? I believe I requested, at least from the liquor board staff, that you bring the confiscated bottles.
Yes, sir.
Okay. Could you produce one or get one out?
Yes, sir.
Okay, and on that bottle, can you tell me what date you're referring to that's noted in your report?
On this bottle, it was bottled 9/11/2024.
Okay, when you say it was bottled, what does that entail and how do you know that?
So obviously with Blanton's, they're very particular about when these bottles are purchased or bottled from the actual distributor from them. No, I'm sorry, the distillery. It actually will tell you when it's actually dumped on. So it was dumped on 9/11/24. From there, it's roughly probably in Blanton's storage for approximately maybe 3 to 4 weeks before it goes to a distributor.
Okay, so how do you know that?
Just from investigations, from my experience.
Have you ever been to the distillery?
No, sir.
Okay, and from whom did you learn that it was probably in possession of the distillery for 3 to 4 weeks?
Well, I don't know. It could actually be shorter. You're absolutely right. Might only be 2 weeks before it actually gets out.
Well, what if it was longer? What if it was a year?
Well, for bottles of Blanton's Gold, which is a allotted bottle, which is extremely
It's an allocated bottle, correct?
Yes, sorry, allocated bottle, which is extremely rare. And as through my 8 months of working this job, I will tell you that this was actually the very first store I actually even saw this bottle in. It is extremely rare. Actually, I see more Pappies, which I don't know if you're a bourbon drinker, is very, very, very popular.
Okay, how many bottles of Blanton's Gold were in Harbor Liquors when you inspected?
On this day, I believe it was 5 total.
Okay, but that's not in your report either, correct?
I only took the 3 bottles, correct?
You only seized 3 bottles, correct?
Yes, correct.
Okay, why did you seize these 3 bottles as opposed to all 5 bottles?
The other bottles had proper invoices.
Okay, when you say proper invoices, I'm going to show you.
I have them.
Well, let's start with the one on 5/7/24. Do you have that one?
Yes, sir.
Invoice 115-664-894.
Correct.
Okay. Can you tell me what bottle of Blanton's was shipped with that invoice?
I cannot.
Okay, why not?
I cannot give you that exactly.
It's not identified on the invoice, correct?
Correct.
Okay. The one bottle is identified though, correct?
One bottle, yes, correct.
One bottle, okay. And that's dated 5/7/24, correct?
The invoice date was dated 5/7/2024, yes, sir.
Okay. How do you know that the bottle, either the 2 bottles that are in that box that were dated 2023 were not shipped on 5/7/24?
Well, I would say that through my experience, my training, obviously knowing the Blantons from going in and doing inspections, which I do regularly every single day, and you see a bottle of Blanton's, a regular bottle of Blanton's, not the Blanton's Gold, but you will see it match up within probably 2 to 3 months, all the time.
Okay.
Much like, if I may, much like a Pappy Van Winkle, which has just been released.
All right, we're not here about Pappy Van Winkle, are we?
No, sir,
Okay,
we're not.
where's that distilled?
I have no idea.
Where's
Kentucky.
Blanton's distilled?
Kentucky.
What's the name of the distillery?
I have no idea, sir.
Where did you get your information about the length of time that Blanton's is kept at the distillery if you don't even know the name of the distillery?
Well, again, like you asked me before, I was never at the distillery, so I don't know that. The same thing is this.
Hold on. So you don't know the answer to that, correct?
Correct.
Okay. Do you think the distillery is identified on that bottle that's sitting right in front of you?
Yes, sir.
Okay. Could you have noted it in the report?
Yes, sir.
Okay, but you did not, correct?
Correct.
Okay, and as you sit here, you still can't read it off the bottle to tell me what the distillery is, correct?
I mean, I can, yes, sir.
Buffalo Trace, right?
Correct.
Okay. So, Blanton's Gold is distilled by Buffalo Trace in Kentucky, correct?
Yes, sir.
Okay. And written on that bottle is the dump date of the barrel out of which it was poured. Is that correct?
Yes, sir.
Okay. And you are telling me that you're sure that this invoice that my client produced, showing a delivery date of 10/21/25, was not for that bottle of Blanton's, correct?
This one? Yes, I would say this was definitely not for this one because I left that bottle.
And why
at
do
the
you say
store.
that? How do you know that?
Because they also got a bottle that was also dated for, I believe it was.
So there was another bottle that you observed that had a different dump date on it?
Correct, sir.
Okay, but that's not in your report either, right?
I didn't confiscate that, sir.
Okay, so you did not confiscate that.
I didn't confiscate that, no.
All right. Let's go to this invoice for 4/8/25. You'd agree with me that they got a bottle of Blanton's on April 8th, 2025, correct?
Yes, sir.
Okay, what bottle did they get that date?
I have no idea, sir.
Okay, but you're sure it's not that bottle that's sitting on the table in front of you, right?
I would bet my life on that one, probably. Yes, sir.
Okay, you would bet your life on it, but you don't know.
No, sir.
You're speculating and you're making a bet, correct?
Yes, sir.
Inherently, it's a gambling proposition as opposed to something you know from personal knowledge, right?
It's more of a, obviously, going in, reading invoices, seeing what invoices are, matching it up when the dump date would be, and understanding exactly how long it would be.
Well, I'm still confused about why you know what the period between when the bottle appears in the store and the dump date is.
A bottle of Blanton's Gold sells for $250.
So?
A bottle
What does that
like
have
it-
to do with the amount of time that it's at the distillery versus the time it shows up from Breakthrough Beverage in my client's store?
It's not going to sit in a wholesaler or warehouse. These bottles are allocated. Obviously, the distributor rewards customers for getting them. They want to get them to the customers. The customers want to purchase them as soon as they possibly can to have them on their shelves.
All right, let me show you this invoice, dated 12/10/24. There's a bottle of Blanton's on that one, right?
Yes, sir.
Okay, how do you know that that bottle wasn't the bottle sitting on this table?
I would actually say that this bottle could very well be that bottle.
So
Yes,
it
sir.
could be this bottle, right?
Yes, sir.
Okay, and yet you still confiscated it.
Yes, sir.
And you rejected this invoice as proof that that bottle was properly acquired from Breakthrough to my client, correct?
Your client produced this invoice afterwards. Yes, sir.
Okay. So this invoice you believe was produced afterwards and not at the time of your visit, correct?
Yes, sir. 100%.
Okay. Do you have any suspicion to believe that this is a fraudulent or false document as I show it to you right now?
No, sir.
Okay. What about this invoice? August 6, 2024.
Yes, sir.
Can you tell me whether or not that invoice is for this bottle?
I cannot.
Okay.
I can tell you that it's not for this bottle. Yes, you're right.
It's not for that one, but
Correct.
it could be for either of those other two that were dumped in 2023, right?
A very, very slim possibility, yes, sir.
Okay. In fact, my client produced to you 5 invoices showing a bottle each of Blanton's, correct?
Yes, sir.
Okay. And you just testified that there were 5 bottles of Blanton's in the store, correct?
Yes, sir.
Okay. But you confiscated these 3 bottles on what theory?
My theory was the bottles that I confiscated were 2023 bottles. They were probably in the store prior to the bulk transfer order when the establishment switched.
Okay, so
I
you
had
just
the bulk transfer order as well, which neither one of those bottles were on.
Okay. So did you review the inventory for the bulk transfer?
Yes, sir. Would you like to see it?
Sure. All right, what date did the inventory transfer? Do you know that?
I believe, if I can refresh my memory, it was February 2024, the date of...
So you don't know that
February 15th, 2024. I apologize. I
Okay, so
remember.
you believe that the license transferred on February 15th, 2024, or the inventory transferred?
E-license shows that the business started in January 31st, 2024, correct? So that's when the current owners took over the business.
All right, could you review that? That's going to be one of the licensee's exhibits. You recognize that document?
Bill of sale, yes, sir.
You ever seen that before?
First time.
All right, that bill of sale indicates that inventory was transferred, correct?
Yes, sir.
Okay, and your belief is that bottles of Blanton's were not transferred as a part of the bulk sale?
Yes, sir. That would be my belief.
Okay, and that's based on what document?
The bulk transfer order, which obviously for everything with what we, in our job, everything when you purchase and sell, we have to come in, companies will pay, come in, actually go and count every single bottle that is being transferred to the new owner.
I'm going to offer and pass up for the board copies of these invoices that I've been asking the agent about. All right, so let me get this straight. You found 5 bottles of Blanton's Gold, correct?
Yes, sir.
The licensee produced for you, and one of the invoices, I believe, was produced subsequent to your visit, 5 invoices showing Blanton's Gold was purchased, correct?
Yes, sir.
Okay, but you don't have any personal knowledge of what was actually in the store at the time of the bulk sale, correct?
Only from the bulk transfer order, which details exactly everything that should be in the store. That was transferred to this owner.
Okay, and your testimony is that that inventory does not show any Blantons, correct?
Correct. It does not.
But it's possible that those bottles were shipped to the store from the distributor and delivered by breakthrough and match these 5 invoices. Isn't that possible?
I would say that those bottles, the 2023, would not match any of the invoices, hence the reason we're here right now.
Well, can you tell that they match the invoices at all?
Again, just from all the inspections that I've conducted in the last 6-7 months, everything just shows me that clearly a bottle of Blanton's Gold, being a allocated bottle, high demand, is not being held for 8 to 10 months.
Okay, where did those bottles of Blanton's come from?
That's a good question. Probably another store.
Okay, you don't have any idea where they came from, do you?
No, sir.
Okay. My client is going to testify that they came from Breakthrough Beverage, and these are the invoices for them. Do you have any evidence to counteract that, other than you think that the bottles are too old, that they were dumped in 2023, so they couldn't have been delivered sometime in 2024? Is that right?
Yes, sir.
No further questions.
Chairman, any questions of the inspector?
Not at this time.
Commissioners, any questions?
A couple questions from me.
Yes, sir.
So from what I understand, some invoices were given to you subsequent to your visit.
Yes, sir.
Is that right? And at least one of those invoices at least shows that that bottle was legitimately purchased from Breakthrough. Is that right?
I would say that this bottle, along with this invoice, would show exactly how fast that these bottles are being into the stores. So a bottle like this, as you brought up, 9/11/24, and now you have an invoice for December, I think it was December 11th, 2024, 3 months, and it's in the store.
So
That is normal from what I've encountered by doing all inspections.
had you seen that invoice at the time of your visit, you wouldn't have confiscated that bottle sitting in front of you,
Correct.
is that right?
Correct, sir. And again, this bottle, and as I told the chief inspector as well when I got here, that with that invoice, that this bottle would easily go back to them, in my opinion.
Are there any invoices that you've seen subsequent to your visit, either today or any time subsequent to your visit, that may substantiate the 2 other bottles that are sitting here?
I don't believe,
your
sir.
opinion?
I don't believe so, sir. Both of those invoices that were given were 8 months, and then it would be 10 months later. I've never seen, even the bottles that we had talked about, the other 2 bottles that were in the store that I didn't confiscate on that date, they were within a 2 to 3 month period that those bottles were actually in the store from the dump date to the invoice itself.
And just because I'm not familiar with these invoices, just to be clear, the invoices don't list the dump dates with each bottle. do
No,
they?
sir. So as much as counsel is saying, I can't tell, neither can he. None of us really know exactly when.
Based on the discrepancy in date, you're sort of surmising that most likely it's from a different source.
Yes, sir.
Okay. When you issued the citation, did you look at the bulk transfer inventory list before you issued the citation?
No citation was issued, sir.
Whatever this is, whatever we want to call this, right?
This is just a report.
Okay.
Obviously,
Before you issued the report, did you look at the bulk transfer inventory?
the bulk transfer inventory was afterwards. Yes, sir.
But you didn't. When you wrote this report, you didn't look at the.
Correct. No.
Okay. Based on the date, though, on the bottles, the bulk transfer permit or the bulk transfer inventory could have justified those bottles as being bought by the previous owner.
And very well it could be, sir. And when that happens, we wouldn't even get to this point. At that point,
Well, you'd already
or-
written the report, though.
Well, again, at that point, we would have issued the bottles right back to the store.
So
It
you would
would
have
have
taken the
been-
bottles, issued the report, and then withdrawn the report.
So all of our bottles go into our evidence control, our evidence office. They stay there. If anything happens, say we've had this issue before, they find more invoices. Prime example is today. I don't want to get into long-winded exactly what happened today. We had 12 bottles of Pappies that we did confiscate today that they swear they can find invoices for. We write the report. We have to submit the report. If they come back and they give us those invoices, those bottles would go back to them before we get to a liquor board hearing. So all of this, and then at that point,
Yeah,
there
I
would
guess
be no liquor board
I'm
hearing.
confused because if I know that the store exchanged hands in 2024 and I see a dump date of 2023, and I believe that the dump date is within, or the delivery is within 3 months of the dump date, I think my first assumption would have been, oh, it must have been part of the bulk transfer.
That is true, but that's also the store's responsibility to provide that information for us. They never even advised of when those dates are. So as we go in, unlike a criminal offense where, when I was in Baltimore City for years, I had to prove the reason I did this, X, Y, Z. In an instance like this is the burdens on the liquor store. They should provide all invoices. Every invoice, any bottle I go in there and I say I need an invoice for this, it is their responsibility to give me an invoice for.
Got it.
So,
or the bulk transfer.
Yes, or a bulk transfer. So
Understood.
anything of that, that's on them. If they don't do that, that's, again, do I have to look at the bulk transfer order if they don't even tell me that that's the case and I asked for it and I've given them ample time and approximately almost 2 months to come to me before today's date? They could have given me 2 more invoices yesterday and I would have been like, that's fine. Then those bottles, you're right. And all of this would have been over and done with, but that is their responsibility for any bottle I ask for in the liquor store. They must have an invoice and be able to produce it, even if it's 10 years old. They have to have an invoice for a bottle in that store.
Thank you.
Yes, sir.
A follow-up based on Commissioner Sung's questions?
Please.
Did you look at any of the vintages of wine in the store at Harbor Liquors?
No, sir.
Okay. You agree with me that there's probably bottles of wine in that store that are older than 2 years old, correct?
Yes, they're definitely, yes.
Okay.
Yes.
And all of those vineyards also have a certain time when they produce wine, and they label their wine given certain vintages and years, correct?
Yes, sir.
Okay. And you didn't evaluate those bottles of wine to determine whether or not that they were in the bulk sale that was identified and that you have with you, correct?
Not on this date.
Okay. Why didn't you do that for the bottles of wine?
On this date, we were looking at the Blantons. That is the only
And
thing I
why-
can tell you, and I can go back and spend a week examining every single bottle that they have. If that's something you would like me to do, I would be gladly to do that.
I'm just asking why it is that you're focused on the Blanton's whiskey and that these invoices that you were emailed, is that correct? You remember
Yes,
being
sir. I was
emailed all
emailed.
5 of these invoices?
Yes, sir.
How long after your inspection were you emailed all 5 of these invoices?
I believe it was within a week.
Okay. So my client did provide to you within a week all 5 of these invoices that we're introducing into evidence tonight, correct?
Yes, sir.
Okay. And that didn't change your assessment, or you didn't talk to the liquor board and withdraw any of these charges as a result of being provided these 5 invoices, correct?
Correct.
Okay. Is there a reason for that? Because I think you just gave contrary testimony that if we had provided the invoices timely in 2 months, that the bottles would go back to the licensee.
Correct. Yes. Well, again, this would be the only bottle that I would be impossible, in my opinion, that could potentially go back.
Okay. And those other 2, it's impossible because why?
Again, I believe the dates that are on those bottles, September of 2023 and October of 2023, both of them should have been on invoices or the bulk transfer order.
Okay, so bear with me. Unbox that one, please. All right, what's the dump date on that bottle?
10/5/2023.
Okay, so how do you know that bottle wasn't delivered in accordance with this May 7th, 2024 invoice to my client?
Sir, I do not know. And I don't think you could even prove that as well.
Okay, well, it's not my obligation to prove it. My client says that that bottle was delivered by Breakthrough Beverage to her store. It's your obligation to prove beyond a reasonable doubt in a criminal proceeding that my client's violated the law, that they haven't paid the applicable taxes, right? So it's your burden to prove. Or is there anything on the other packaging, on the bottle, additional packaging, the box or the bag that you're relying on?
No, sir.
Okay, is there any other identifying information published by the distillery on the bottle other than the dump date?
No, sir, just a dump date.
Okay, is there any other information that you reviewed from the distillery to help you determine that that bottle, the second one that you unboxed, which was dumped in 2023, was not delivered in May of 2024?
Again, other than the fact that everything that I've come across with these bottles and how you get them, it is a solid 2 to 3 months before. It's not going, nobody's going to hold a bottle of Blanton's Gold for 8 months to 10 months.
Okay, how do you know that Breakthrough Beverage didn't hold it for 8 to 10 months?
Again, talking to supervisors at Breakthrough.
So who did you talk to at Breakthrough?
Adam Gostomski was his name.
Adam Wisconsin, what's his position?
He's a employee supervisor for Breakthrough.
Okay, do you know his position at Breakthrough?
No, sir, I do not.
Do you know if he worked for Reliable Churchill?
I do not know. He might have. He's been with the company for many years, so it might have been that first.
Okay, so you don't know how long his tenure was, correct?
Correct, sir.
Okay, and you don't know what his job position title is, correct?
No, I don't.
Okay, and when did you talk to him?
It was shortly after this time.
Okay, did you talk to him in person?
It was via phone.
So you talked to someone who said his name was Adam on the phone at Breakthrough, and he told you what?
Well, he told me basically that he didn't want to get involved. And I said, why is that? He said, honestly, a lot of the stuff that we do, we don't want to work with you guys. And I was like, okay, well, I'm not going to use your name because obviously in what they do, I understand what they do. And they help each other out from store to store and under the circumstances. But I would say that he was like, from what I've seen, a bottle of Blanton's Gold, which we do not even get that much, that bottle would not be anywhere close to take that long to get to a store.
Okay, so your entire case is built on something that a person named Adam told you on the phone. Is that right?
No, sir. No.
Okay, what else is it built on?
Again, the only thing I'm saying is the dump date and the invoices provided for me through my experience of going into these stores, matching up invoices within 1 or 2 months. There is nothing that shows me at all on the bulk transfer. Nothing at all was provided to me that would show that, yes, these bottles were delivered in a timely fashion.
Okay, but you...
Mr. Lyman?
Yes.
It was 1 or 2 questions after Commissioner Sung's question.
Very good. I'll have no further questions this time with Agent McGee. Thank you.
Mr. Chairman, did you have any follow-up questions for the inspector?
I do. Just for clarity's sake, Agent, on October 22nd at 11 a.m. when you went to that store, before you left that premises, were you given any invoices, bills, papers, or anything that would make you think that those bottles that you have in your possession now were legitimately purchased through a distributor?
No, sir.
Did you ask the licensees or any representative if they had any additional paperwork at that time?
I said the same thing like I explained. I said, if you come across any more invoices, please, by all means, send them to me.
And did you get those invoices prior to tonight or see those invoices prior to tonight?
Yes, sir.
Okay. And when was that?
Again, those invoices were provided approximately a week after.
A week after?
Yes, sir.
Okay. Very good. I have no further questions at this moment.
It's your case, Mr. Lyman.
I'm going to call Ms. Patel, the licensee. Obviously, we're entering a not guilty plea if that's required. Ms. Patel, can you identify these 5 invoices for the board and tell me what they are?
Okay, these are the invoices that we get all the allocations and it comes randomly. We don't know which barrels we get when. So basically, my thing is that
So hold on. Just identify the documents for me. Just tell the board what these documents are.
these are for the lanterns allocations and we have all of them got one in the May 24, then in August 6, 24, April 8, 25, and December 24th.
All right, and how many invoices do you have there to present to the board?
5.
Okay, and each of those 5 shows a bottle of Blanton's Gold being delivered to your premises?
Yes.
Okay. I'd moved in the licensee's exhibits that I handed up before, the breakthrough beverage invoices.
So admitted.
I'm going to move in, I've just got the one copy of the bill of sale that I showed the agent before. I'm going to move this in as licensees 2.
So admitted.
Ms. Patel, do you have personal knowledge of where the bottles that were seized actually came from?
Comes from the company.
I'm sorry, give your answer, say it clearly into the microwave, or the microphone, sorry.
So basically, whichever bottles comes, it comes from different distributors, and these bottles comes from the breakthrough. It's allocation, so it comes any time of the time. So we don't know which bottles they produce, what kind of date they manufacture, and what time they give, and they send us to the stores.
Okay.
So that's all I know about it.
Do you know where the bottles that were seized actually came from?
Nope.
They didn't come from Breakthrough Beverages and were delivered with these orders?
Yeah, they come from the company Breakthrough, yeah. That's all I know.
Okay. You didn't get any bottles from anywhere else, did you?
No.
Okay. And are these all of the business records that you have relating to Blanton's Gold bottles?
Yes.
Okay. Do you know how many bottles you have in inventory left now?
Probably, we had it 5, and if I sold one, then maybe 4. And I think they took some of them, so I don't think so. We have maybe 1 or 2 maybe in the store.
Okay. Did you pay all the taxes on the Blantons that were listed in these invoices?
Yes.
Okay. And were these records provided to Agent McGee?
Mm-hmm.
Okay. No further questions.
Mr. Chair, any questions?
I do. Did you actually go to the store the day the agent was there on October 22nd?
No.
You did not go there?
No, I wasn't there. I was out of country for 2 weeks, so
Okay.
I wasn't there.
No,
that
that's,
time.
I understand. Sir,
But
were you
my manager
involved
was
on it
there.
in that day?
Yeah, he
All
was
right.
here.
Then my question would be to you at this point. Did you provide the agent with any of the paperwork at all that he requested at that time, which is October 22nd around 11 a.m.?
I give you all the invoice for he, but one missing for the invoice. She sent the email.
The bulk transfer that we talked about, was that provided to you, agent?
No, sir, the bulk transfer was never given to me at scene.
Was it
He did
mentioned-
provide invoices.
I'm sorry?
Mr. Knight did provide invoices for me on scene for some of the bottles that, yes, he did, but no, nothing with the bulk transfer at all.
Ms. Patel, did you have a copy of the bulk transfer on site at your store?
We did have it, but I keep my records at different place, so my manager didn't know anything about that.
So it was there,
that
but he
moment.
didn't know where?
Yes.
Okay. Did you receive a phone call from your manager?
Yes.
And did
We
he
did
ask you?
We did have a talk. after these things happened, and then there was a one invoice missing, but we found it later on, and we emailed them back right after we found it.
Okay. All right, no further questions.
Commissioners, any questions?
Quick question from me. I see that based on the invoices, the 750 milliliter Blanton's is about $100. It ranges from like $110 to like $99. But on the invoice that's on the third page, the Blanton's price jumps up to $359. Why? Do you know why that is? Third page.
I'm afraid, sorry, Commissioner Sung, I handed all of the copies up to you.
We have extras.
I didn't count them very well, I apologize. So Commissioner Sung, you're asking about the third page?
Yeah.
Blanton's?
Yeah. Is it a different type of Blanton's or a special
Blanton's Gold
edition?
Bourbon is the top line item on that third page. That's this one?
Yes. So that one has a price of $359.99, whereas the others are about $100.
I don't see that, Commissioner Sung. I see the unit
can I-
price is
can I answer?
$110.65.
Can I answer for you?
Oh, is that a different type?
That's just standard.
Objection.
I'm sorry. I know, but this one. Oh, it's a different type. Okay. So we're not alleging that $359 is one of the 5 bottles that were at the store at the time.
Oh, the Blanton single barrel bourbon that's about 15 lines down.
Yeah.
If you look at this invoice, that's a case price. So that's $359.99 for 6 bottles of that particular product, which is Blanton's single barrel bourbon, which is different than the Blanton's Gold Bourbon, which is the very top line item on that invoice, Commissioner Sung.
So the 5 bottles that were at the store at the time of the inspection are the 5 $100 bottles, not including this.
I believe we were talking about Blanton's Gold Bourbon entirely between me.
Sorry, I'm not a drinker, so I'm not
and the agent.
very familiar. The different types of blends. Okay, so it is a count of 5 relevant Blanton bottles according to these invoices, correct?
I think everybody's talking about the Blanton's Gold, which is a single barrel pour is the marketing that goes with that. It comes out of a single barrel. Each of the bottles is specifically numbered, and the date of the pour is actually written in Sharpie or whatever on the outside of the bottle.
But your intention in submitting these 5 invoices is to show that these 3 here and the 2 that were left at the store are these 5 bottles. That are on
That's
these
exactly
invoices.
right. There's one
Okay.
bottle listed on the top line item of every one of these
Got it.
pages, Commissioner, and that's the licensee's testimony is that these are the 5 bottles that the agent located at the store.
Is there any way that the licensee can, at least in their opinion, identify each bottle with each invoice, link up each bottle, or is that not possible? No. They have no way of doing that?
It's not as if they have individualized serial numbers or
Based on the
anything
dates? No, dump dates, invoice dates, no.
I don't know necessarily that you're even going to get that in her store as far as the inventory control, that there's any way for her to tell this bottle is delivered on this particular date. These are rare bourbons, but other than that, very similar to all of the bottles of wine, records are supposed to be kept for 2 years. I mean, arguably, if the dumps were older than 2 years and those got delivered within 2023 before my client even got the store, they were picked up in 2025. If more than 2 years have elapsed, then we've got a 2-year requirement under the statute to hold the records. Any bottle in the store that's older than 2 years old, officially, you don't really have a statute that says you have to have a record for that. I mean, that's argument to some degree, Commissioner, but the reality is that we provided the 5 invoices for the 5 bottles of Blanton's Gold, and our contention is none of them deserve to be seized.
Got it, thank you.
The 3 agent, I'm sorry, Agent McGee, the 3 bottles that you have, they're the only 3 bottles that you confiscated on that day. Am I correct in that saying
Yes.
that that's why they're here tonight in evidence?
Yes, sir.
I understand Mr. Lyman's point, but I also understand the point of the state. You know, we need to have records that indicate that the inventory that you have, that those records matched that inventory in some form or fashion. And it makes it difficult. It would be easier if they had serial numbers. We could match
Yeah,
them.
but we have no choice. I mean, I even tried to talk to my sales reps who are from Breakthrough, and we asked them like how these things work. You know, we don't know like when that dates are on that barrel. We don't check those dates when we receive the deliveries because those are the allocations. So it comes anytime, maybe once a month, or could be more than that. So during that time, we didn't see that date that came on that invoices, you know, and which invoices had what date and which barrel has which date, we didn't know about it. The only thing I knew that we have all the Blantons that in the store, and we had the all invoices.
Excuse me. The box that you have, is that the box that these bottles were in at the time you found them, or is that just the box you used to carry them here?
That box right there, sir? No, that was, I took just the 3 bottles out, and then I put them in a box.
Okay, but that's not the box that the bottles were in originally, so therefore there wouldn't be a label on it that would indicate anything. I'm sure you would have checked it at the time, correct?
Correct, sir.
Just
Yes.
wanted to clarify that, that's
Yes.
all.
And most times when you get a bottle like this, it does only come one bottle at a time.
Does not have any descriptive dates or anything on it, is that correct?
No, sir.
Yeah, I thought you testified to that in Mr. Lyman's question. Okay. All right.
Mr. Hurdle,
think
may
we
I
understand each other.
may I
Alright.
give an argument and summation?
Yes, you can.
Please, Mr. Lyman.
The way that my client is looking at this case is that the business records that she has kept in the normal course of business that are actually generated by Breakthrough Beverage do not identify the product with sufficient particularity to identify bottle by bottle. Mr. Chairman, that's exactly what you were just pointing out by your line of questioning at the very end here. Because of that, the question really is, well, who do you give the benefit of the doubt to? Do you give the benefit of the doubt to the licensee who has 5 invoices that match 5 bottles of Blanton's Gold that were located in the establishment on the date of the inspection? Or do you give the benefit of the doubt to the agent who suspects that those bottles must be too old because it would be faster in the stream of commerce that they would be provided to the stores, and that it's not a possibility that those would have been provided in accordance with these 5 invoices? That's the tension that the board faces. And frankly, if this were a criminal court, it wouldn't even be close.
It's
Okay.
not a criminal court. We've gone that road before.
And I understand that, okay? And I'm not suggesting that a reasonable doubt standard is the standard here. My suggestion, though, is that if you're going to break the tie, you should listen to the testimony from the licensee. You should listen to the testimony from the licensee about the records that she keeps in the normal course of business, right? Maybe if this is going to be a problem, a notice or a publication from the board or from the ATCC is appropriate to put licensees aware that they need to check the dump dates on the bottle, because that's not something that the licensee would know otherwise ahead of time, because the dump dates on the bottle necessarily must be different than the invoice dates. The dump dates in the bottle, it happens in Tennessee at Buffalo Trace Distillery. And then those bottles must flow through interstate commerce. They have to make it, we don't even know whether they go straight to breakthrough or whether there's another distributor who touches those bottles before they make it to breakthrough. You don't have any competent testimony from any witnesses here tonight about that process at all. What you have is an agent who's been working on this for 8 months who suspects that these invoices are too old and don't match the bottles that he sees from the store. And that is pure speculation if the board were to accept that. Thank you.
Okay, thank you, Mr. Lyman. I could have saved you that time on that, but I wanted to hear from you. No,
Thank you, Mr. Chairman.
all right, I'm going to make motions here in this case, and I'm a little befuddled on the system that we have nowadays. It starts from the distilleries all the way to through here, that we can't identify these bottles a little better than the dump dates, but it is what it is. What I'm going to do is I'm going to make a motion and give you that benefit of the doubt you asked the board to have on the charge of the restricted purchases and sales by a retailer. I'm going to make a motion that we find you not guilty in that, but as far as the record keeping and reporting requirements, I'm going to make a motion that we find you guilty of that. Whether you're in the establishment or the store at the time or not, your managers need to be well aware of where all the records are so that they can give them to the agents or the inspectors when they come in. And so my motion is going to be not guilty verdict on the restricted purchases and sales to a retailer or by a retailer, and guilty on the record keeping. And I'm going to make a motion that the fine be set at $500 for that. So I'm looking for a second.
I'll second.
Okay, I have a second. All in favor?
Aye.
Aye.
Okay.
Mr.
Lyman,
Harrison and Ms.
you-
Hurl, I have one ancillary matter, and this as actually pertains to the bottles themselves. I'd like to cite for the board Alcoholic Beverages Article 6202C1. If the license holder or permit holder is found not guilty, alcoholic beverages taken as evidence shall be returned to the license or permit holder. And I would like to request that that occur now, just to make sure that it actually happens. My prior not guilty on one of these seizures from the ATCC is still looking to get their inventory back. So I just bring that up as an ancillary matter, given the ruling from the board, and I'd be happy to hand up the statute if it needs to be introduced.
Mr. Lyman, I understand what you read. It's our understanding and our experience with ATC that the decision to return that is made by them, but at the same time, you're more than happy to communicate with them that they were found not guilty. And whatever the Alcohol, Tobacco, and Cannabis Commission decides to do is acceptable to this board.
Very good. I understand. Thank you, Mr. Chairman. Appreciate the consideration of the request.
Okay.
It's just a matter of custody. They're not in our custody. They're in the ATCC's custody.
I understand that. The statutory regime makes it clear whose custody seizures are in is important. So, thank you.
Thank you.
Thank you. Thank you, Agent.
All right, our next case is for Bay Hills Golf Operations LLC, trading as Bay Hills Golf. Henry McLaughlin Jr., members excuse Ray Salzer, member Kevin Havens, member Chief Dwayne Gottschalk, Inspector Mark Mucklebauer, Class D Tavern license BWL, Sunday license with outdoor service, located at 545 Bay Hills Drive, Arnold, Maryland, 21012. No restrictions on the license. There's one violation for rules and regulations of the Board of License Commissioners, Randolph County, Chapter 4, Section 4.18, titled Alterations in reference to Board of License Commissioners, Randolph County violation notice number 1608 by Mark Mucklebauer, dated October 22nd, 2025. Anyone wishing to testify for or against, please come forward, remain standing, raise your right hand. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Starting from my left, Inspector Mucklebauer, can you please state your name and address for the record, or name and position for the record?
Mark Mucklebauer, Inspector, Anne Arundel County Liquor Board.
Thank you. Name and address for the record, Mr. Salzer.
Raymond Salzer, 185 Rock Ridge Road, Millersville, Maryland, 21108.
Kevin Havens, 359 Preston Field Lane, Severna Park, 21146.
Thank you. Mr. Hurdle.
Inspector, I'll turn the case over to you.
Mr. Hurdle, prior to my statement of facts, I would like to make a motion that my report and all the attached exhibits, which has also been provided to the licensee and the licensee's counsel, be moved into evidence and become part of the record.
So admitted.
On June 11th, 2025, Chief Gottschalk sent a photograph to me via text message of a ad regarding live music at Bay Hills Golf Club on Friday nights. Shortly after, I responded to Bay Hills and entered the premises and proceeded upstairs to the snack bar area. Upon observation, I noticed a significant difference as compared to my previous visit on November 25th, 2024. I requested to speak to a licensee, and an approved manager contacted the licensee by telephone. And I subsequently spoke to an individual who identified himself as Harry McLaughlin. He is listed as the licensee. I explained my primary reason for the visit was regarding the live music, and they do not have the proper entertainment permit for live music. I told him to cease and desist this practice. He said it's not a big moneymaker, and he would cease. I explained that if Bay Hills wanted live music, they would have to apply for the proper entertainment permit. I then reminded him that any structural or layout changes to the licensed establishment must be first reviewed and approved by the liquor board. When questioned about the newly configured bar area, he stated that the modifications were primarily cosmetic. I advised him to notify and consult with the liquor board regarding these alterations. This interaction was documented in a supplemental report dated June the 11th, 2025, and additional notes were included in my annual inspection August 11th, 2025. Chief Gottschalk communicated with me stating a grand addition had been made on the outdoor seating area, and the deck is expanding to wrap around the east side of the clubhouse. On October 22nd, 2025, Chief Gottschalk and I conducted a follow-up visit to the Bay Hills Golf Club. The patio cover of the east side of the building had been removed, and the area had been flattened as to serve as the foundation for the new upper-level deck expansion. Upon arrival inside, we were greeted by a board-approved manager, and I requested one of the licensees, Mr. Sawyers, I requested to speak to one of the licensees, and Mr. Sawyers met with us shortly thereafter. Mr. Sawyers stated that he was not aware that the interior bar renovations required prior approval of the liquor board. He further explained that he believed the interior work was included in the recently submitted request for the expansion of the outdoor seating area, and noted that they have applied for an entertainment permit. Based on my findings of both visits, Notice of violation 1608 was issued for prohibited practices alteration, section 4.18A. Follow-up, on November 5th, 2025, I responded to Bay Hills. The entire east side of the clubhouse is now covered with a new second floor deck. The rear railing of the east side was removed and transitioned to merge the decks together as one. These facts are documented in the photographs taken November 5th, 2025. And those are my statement of facts and into my report.
Mr. Chairman, any questions of the inspector?
Inspector Mucklebauer, did you ask them if they had the proper permits for the work that was being concerning the alterations?
I did not.
Okay. I have no further questions at this time with the inspector.
Commissioners, any questions?
I have no questions.
No questions. Mr. Pickett?
Good evening. So this expansion, I would say, is not an expansion. Rather, it is a modification to the floor plan. It actually reduces the amount of floor area. It is purely aesthetic, and it stems from the application that was submitted to the board. Along with the application, the updated floor plan was included. It was sent back and forth several times to the board. The board asked for different updates, different changes to it, and my client complied with that. We are not saying that we are not guilty. We understand, my client at the time did not understand, but does now, that you need to ask for permission before you do anything to the floor plan. With that being said, I think there are situations where floor plans, floor area is increased and it is done without the board's permission in an effort to circumvent the board and hide it from the board. That is not the case here. My client believed that the board was fully aware of the new floor plan, what they intended to do. Again, with that being said, my client is aware and is now, confirming that it is their duty to understand the rules of the board. We've talked about that. While it is a mistake, we know that we still must comply with the rules. But I would ask that as you make your decision tonight, that you take into account that this is not a situation where the board was intentionally subverted. It was an accident. That's plain and simple what it was.
Mr. Chair, any questions?
I have a few. You say it's not really alterations.
It's not an expansion, rather. They're not.
It's not an expansion, but it's alterations.
Right.
Okay, well, I just wanted to get that straight first. The garage doors that I see in the photos, were they originally that way or were they just put in?
They were same size, so yes, that was for the original conversation with Mr. McLaughlin, that the aesthetics and that needs to be communicated also if we are going to be updating any of those channels.
Have you did you obtain a building permit from the Anne Arundel County Building and Inspection Division in order to make these alterations or changes?
We received a permit for the deck and went through those channels to add that deck and remove the pavilion. So that was a reduction from the 40 by 50 to the 20 by 50 deck that was going to be put in that place.
You've had an opportunity to meet Inspector Mucklebauer, I would imagine, if you're on site, correct, or no?
Not during the first meeting about the live music, but I was on property when Chief Inspector and Mr. Inspector Mucklebauer was there.
Okay. Well, I just want to make sure you're aware of the fact that everybody sitting at this table in front of me and between you and I are in the office, 5 days a week, 8 hours a day, to answer any questions you have or if you need direction on anything. We also have a rule book, of which a copy is online. And you'll notice there's something about alterations in that as well. So overall, you've had a pretty good track record, if I may. And things like this can slip by, but we want to make sure every licensee is well aware of the rules and regulations that they have to abide by. And just like with the driving, you understand that when you take that driving test and you get that license, you have to, because they will assume you have read that book and know all the rules of the road and so forth. And that's the same thing with these rules and regulations and state laws that pertain to any place that sells alcohol. And the only reason I went into that in any detail is I have another follow-up question that pertains to your golf course. And that is, you have a beer cart, correct?
Yes, sir.
All right. The employees who operate that beer cart, how old are they?
They're 21. They could be 18, though.
I'm sorry?
But they would be 21. But you could have an 18-year-old out there, but they can't pour.
So if an 18-year-old was in one of your golf cart and pulled up to my foursome and I asked...
Historically, right now, we are only employing 21-year-olds. In my past, since I've been in the position since GM previously before ownership, there have been 18-year-olds that would just not pour. Not on a beverage cart, but I'm talking about in a pull service. You could tell me if that's wrong in the book.
Well, we're gonna enlighten you.
Okay.
Okay.
Yes, sir.
The only reason I brought that in is I did not want to forget to address that before you walked out of here, because I do think it's important. I have no further questions when it comes to the alterations. I'm going to submit to the other commissioners.
Commissioners, any questions?
I have no questions.
Okay.
May I just say one more thing before
Absolutely, Mr. Pickett, please do.
I just want to, I don't know if, I live down the street from Bay Hills. That's my home golf course. I've been going there for a while now, and prior to their ownership, and if you're, it would be described probably as a dog track before. You've got wonderful owners now that have done a fantastic job with that golf course, and personally, I'm very thankful for it. So I would just say that you've got licensors who are trying to, or licensees rather, who are trying to make the place better and have put a lot of time and effort into it and are trying to go about things in the right way. And I think this is a learning moment for us, but I would also take that into consideration that they've done a fantastic job overall.
And I would like to say one thing about the permit and the channels, right? We went through the permitting process on getting this deck done in November of 2024. It took us a year to get there. And through the channels, we solicited and we requested our council to help us out through that process to do the entertainment license. But the entertainment license, we did the floor plan a couple different times. So yes, it's unfortunate that I needed to go through another channel to get that approval, and now I understand that. But that was that's something that I've learned through this process.
Okay, very good. Thank you both for that. It is important that you understand, and everybody else who has a license, that the administration is in that office. And if you have any questions, you please feel free to pick up the phone and call them. I'm going to make a motion. I'm going to find you. Well, before I do that, let me ask you a question. The alterations that were done inside, I am a golfer and I have occasionally been to your golf course, and I like it, but beside the point, I know it's quite a bit different now than what it was not too long ago as far as the inside. This inspector comes in several times, if not more, a year to check licenses and so forth. I think it would behoove you to make sure that your staff, whoever it might be, is well aware that if he comes in and they have any questions, that they address it to him, or again, pick up the phone and call. I'm going to go ahead and make a motion that we find you guilty of the alterations, and I'm going to make a motion that the fine be $250. And I'm going pretty easy because I don't believe it was intentional, and at the same time, I believe you are guilty of violating the alterations rules. But I'm going to put a restriction on your license, and this is what I referred to when I asked you about the beer cart. I have concern about 18-year-olds being out there on a cart and handing somebody a can or a bottle of wine or whatever. Even though they may not open it, they are dispensing it. They are selling it, and there's no adult with them normally. I know when you have your golf outings, you know, there's lots of times you'll have two people in the cart. So I'm going to put a restriction on your license effective immediately that simply says all individuals working at a point of sale, and the point of sale is in this case because they're collecting the money, right, on the cart, be Maryland approved, alcohol awareness certified, and a minimum of 21 years of age. Okay? I think you're going to find that we're going to change we hope to change the rules and regulations concerning golf courses, which will benefit you in the future, but I think this is something you're going to see also with the other golf courses. We need to make sure that nobody under the age of 21 is dispensing alcohol in that form or fashion. Now, when it comes to your upstairs dining area, that's a little different. You're talking about a cashier who opens a bottle of beer, hands it to an 18-year-old. She can walk it over to the table and put it down. That's a little bit different. She's there. She's in a controlled situation out there on a cart in the middle of the fairway. It's a different circumstances. So that's my motion. I'm looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Aye. Okay. Good night. Lots of luck. I hope your
Thank you.
alterations, changes will work out
Thank you.
for you.
Thank you, sir.
Uh-huh.
All right, our next case is for Tango Arundel LLC, trading as, thank you. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Do you want to make them all go back? No, let's just go forward. Please raise your right hand. Yeah, please remain standing and raise your right hand so I can swear you in. Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Starting from my left, can you please state your name and address for the record or position?
Inspector Frank Faulkner, Anne Arundel County Liquor Board.
Leanne Schreckengoss with Royston, Muller, McLean, and Reed here on behalf of the applicants.
Scott Rossick, 7149 Baxter Shire Drive, Dallas, Texas, 75230.
Adolfo Rodriguez Jr., I'm Chief Legal Officer of Dave & Buster's. I'm at 1221 South Beltline Road, Suite 500, Coppell, Texas, 75019.
Kevin Waldemar Atanaso, 1043 Park Road, Crownsville, Maryland, 21032.
James Lang, 1307 Washington Drive, Annapolis, 21403.
Thank you. Mr. Hurdle.
Inspectors?
Mr. Hurdle, prior to my statement of facts, I'd like to make a motion that my report and all attached exhibits which have been provided to the licensee and licensee's counsel to be moved into evidence become part of the report.
So admitted.
Mr. Hurdle, I have no objection to the report. Were there any exhibits that I did not receive any exhibits? I don't actually think there are in this case, but I just want to be clear.
Inspector, were there any exhibits beyond the report?
No, sir.
Thank you.
Wonderful. Back to you, Inspector.
Okay, on Friday, September the 5th, 2025, at approximately 11 a.m., Deputy Chief Inspector Ralston and Inspector Faulkner went to Dave and Buster's, located at 700 Arundel Mill Circle in Hanover, Maryland, in response to an anonymous complaint that was received by the Liquor Board regarding an incident on August 24th, 2025, around 9 to 10 p.m. that involved the manager, Heath Alton Garling, serving alcoholic beverages in exchange for female patrons exposing their breast. The complaint stated that the manager encouraged the behavior by the female patrons within view of other staff and guests within the establishment. On Friday, Deputy Chief Ralston and Inspector Faulkner met with Dave and Buster's manager, James Lang, and confirmed that he had access to video footage for the date in question. Manager Lang confirmed he has access and questioned if it was for the incident that occurred on August the 24th, which Deputy Chief Ralston and Inspector Faulkner confirmed. Deputy Chief Ralston and Inspector Faulkner and Manager Lang observed the footage of 6 females and 2 males at the bar next to the bowling alley from approximately 8:30 p.m. to 10:15 p.m. All 6 females were observed ordering multiple drinks during this time, while no age identification was requested. Neither of the males were observed drinking any type of beverage at the establishment during this time frame. One female was observed vaping throughout the time frame, at times in front of the manager and staff. At approximately 9:45 p.m., one of the females was observed exposing her breast while the manager was in discussion with her and those seated next to her. Mr. Garling did not react to her actions or to refrain from continuing action, rather continued conversation with her and those seated next to her. During this time, those seated at the corner of the bar were unable to be seen due to the angle of the cameras. Due to the camera angle, it appeared that another female in the group revealed her breast as well, but neither Manager Lang, Inspector Faulkner, nor Deputy Chief Inspector could confirm this footage. In conjunction with watching the video footage, Manager Lang reviewed the receipts from the point of sale system. We collectively observed the female in question drinking 2 alcoholic beverages and 2 shots during the entire observed time frame. From the receipt research, Manager Lang was able to confirm the receipt for the patrons' 2 drinks, but unable to find the sale for the 2 shots. Manager Lang also surveyed receipts during this time frame, but was unable to find the sales of the shots that the group received. The group of 6 females and 2 males were observed exiting Dave & Buster's approximately 10:30 p.m. through the mall entrance. During the investigation, Manager Lang was cooperative and helpful throughout the entire investigation process. In addition, Mr. Lang forwarded us that Mr. Garland had been counseled for his performance and behavior in relation to the event of August the 24th. Mr. Lang confirmed that the video footage remains on their system for 90 days, and if need be, specific video clips can be saved for future reference. And the report.
Ms. Schreckengost.
I have no questions regarding the report.
Chairman, any questions?
Well, I'm impressed with the fact that Mr. Lang went through quite a bit to be cooperative and work with you and the deputy chief. Am I correct in saying that? Is that what you said? Correct. Well, thank you, Mr. Lang. We do appreciate that. And I know it's tough when it's happening in your establishment. So thank you. And also, I believe you said in your report, Inspector Faulkner, that the cameras, and Mr. Lang might be able to answer this as well, but in reference to your report, that there was obviously alcohol being served, but no monies in trade at that time or being offered at that time. Is that correct? In other words, were they paying for those drinks, the young ladies?
If I may, Mr. Chair, I observed the videos myself personally. They did pay for some of the drinks. There was some money exchange. Based on the research that Manager Lang, it does appear that they did not pay for all of the drinks that were consumed.
Thank you.
But there was some money exchange. There were some ring up, but we cannot confirm for a fact that there was nothing given away for free. So we do acknowledge that.
Thank you, Ms. Schreckengost.
Certainly.
Okay, I have no further questions.
Commissioners, any questions?
No questions.
Ms. Schreckengost?
Thank you very much. Well, obviously, we're quite embarrassed to be here under these circumstances and for these reasons. It's demeaning and embarrassing, and none of these gentlemen want to be here in front of you for this. As indicated in the report, the manager at the time was counseled. After a subsequent investigation and after the inspectors came in, he was terminated. The facility will not put up with this activity at all. There have been, all the management team was immediately counseled about what happened, how they cannot condone any type of behavior like this. You cannot spend your time interacting with guests. Your job as a manager is to be patrolling the floors to make sure incidents like this don't occur. They have been instructed that if they see any type of inappropriate behavior, whether it's vaping or indecent exposure, the guest is to be counseled. If they do it again, they are to be immediately escorted off the premises. This is not tolerable at all. They have put up new and additional signage around the facility to remind people that vaping is not acceptable. It's against a health code violation. It's a health code violation, and it's just not permissible. Those additional signs have been put up, and all the managers have been I'm sure most of you have been out to a restaurant where you see people. I notice it everywhere, unfortunately. People don't realize and don't pay attention that it's not acceptable. They've all been retrained that this is not acceptable behavior. People must leave your premises if they are caught vaping. Like I said, the manager has since been terminated. I will go through, I do have concerns. Like I said, we admit to the vaping, we admit to the exposure, but it was not something that rises to the level of sexual practices and obscenities. And I'm happy to go through that rule point by point with the board as to why I feel like that does not apply, but we fully acknowledge that sanitation and safety, public welfare, like I said, the free food and prizes, we can't confirm or deny that that did not happen. And as far as unauthorized conduct, I do feel like the vaping and the exposure do follow under all of those categories. But as far as the sexual practices and obscenity should not apply to this case, that is for people looking to solicit employees who are creating bad acts or entertainers who are creating bad acts, not for patrons who are simply exposing themselves inappropriately. So I would ask that that charge be withdrawn and dismissed altogether.
Ms.
Certainly. Yes, yes, it's board rule 415. Section A of the rule specifically states that no licensee shall permit, suffer, condone, authorize, or sponsor any of the following activities to occur on the premises. With respect to attire and conduct, everything listed under is specific to employees. We don't have an employee at issue here. We have a patron who exposed herself. So in my opinion, Section A of that rule does not apply to this instance.
What'd you say to section B and C?
B and C. Section B, no licensee shall permit or suffer the licensed premises to be used for the purpose of sexual activity, nor shall any licensee permit or suffer any employee, patron, or friend to solicit any person for prostitution or immoral person. There was no solicitation here for prostitution or for immoral purposes. Yes, exposing herself does not fall under a licensee allowing her to solicit anything. So I don't think B applies at all, and it says no licensee shall permit or suffer the licensed premises to become a disorderly house. A disorderly house, by definition, is a house of prostitution, a house of gambling, a house of drug use, and a house of public intoxication. Neither of those apply to this situation either.
Thank you, Ms. Schreckengoss. Is there anything else? Well, I do have a few questions for the licensees. I know your establishment very well. I was your inspector for many, many years. And to be honest, I've always felt that it was a very good place for our youth as well as our adults to visit. We were participating with your after-prom parties that you had every year. I can remember when you used to have 12, 14 of them a year. I understand it's dwindled down. Mr. Lang, he's well aware of how we worked alongside of your staff. I was really quite surprised and very upset reading this just a few minutes ago. And I feel like I mentioned earlier when the one employee was let go, that perhaps in this case that was the appropriate action to take. And I think this rises a little bit higher than the normal standards because you do work with and you do have all of our youth or a lot of our youth at your establishment. And I think that you really need to be extremely careful with how you handle those patrons. And I can understand where Mrs. Schreckengost is going with the rules and the regulation in this particular case. It probably does not pertain to that particular charge, but looking at the other 4 charges, every one of them pertains in this case. So with that being said, I'm going to go ahead and make a motion, and my motion is to dismiss the charge Ms. Schreckengost talked about, which is a sexual practices and obscenity, and I'm going to find you guilty on the other 4 charges. Sanitation and safety for obvious reasons, sale or free alcohol, because we do have an admission that there was some that was given away, public welfare in general, of course, and the unauthorized conduct. It all pertains in this case. Now, I'm going to find you guilty or make a motion to find you guilty and make a fine of $750 in each of those 4 cases. So we're looking at a total of $3,000 in fines. And I hope you realize that under the circumstances, especially because of our youth going there, that you're lucky you don't have a suspension of your license, because that's how serious something like this can be. And I'm sure Mr. Lang will be watching his employees very carefully going forward. So my motion is guilty on all 4 of the charges, $750 per charge, a total of $3,000. I'm looking for a second.
I second the motion.
Okay, thank you. I have a second. All in favor?
Aye.
Aye. Done. Have a good evening. Thank you for coming in, and please be careful in the future.
Thank you.
Our next case is for Melody MAA LLC, trading as Preserved Wine and Spirits. Havel Patel, authorized member. Tushar Patel, authorized member, excused. Kapoor Patel, Detective Middleton, badge 1061, Detective Mountcastle, 1155. Inspector Frank Faulkner, it's for a Class A package, BWL. The BWL tasting and Sunday service located 7698 Dorchester Boulevard, Unit 101.
Counsel, do you waive reading?
Yes, I'm sorry, waive reading.
Thank you. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. Thank you. Do you solemnly swear in affirmative the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Please be seated. Starting from my left, can you please state your name and address for the record?
Good evening. Detective Middleton, Anne Arundel County Police Department.
Kelly Kylis, McNamee Hosty, on behalf of the licensee.
Dawal Patel, 9228 Homestretch Court, Laurel, Maryland 20723.
Vipul Patel, 1519 Ketla Court, Hanover, Maryland 21076.
Thank you. Mr. Erdl?
Before we get started, has Detective Middleton been sworn in? Yes. Wonderful. Thank you. Detective.
Good evening. Sorry I was late. I was tied up with an arrest at the detention center. So finally made it. So this was, incident was October 28th of this year, 2025. It was approximately 5 p.m. Detective Mountcastle and I were working Operation Save, conducting alcohol sales compliance checks for retail businesses. We directed a confidential source, 20 years of age subject, to enter the Preserved Wine and Spirits at 7690 Dorchester Boulevard, Unit 101 in Hanover, Anne Arundel County, Maryland. We verified our confidential source's age to the Maryland Motor Vehicle Administration, provided a certified copy of the driver's license identification. I have that here tonight if you want to take a look at that. Confidential source was searched prior to the detail, make sure she did not have any money, alcoholic beverages, or identification on her person. We observed her enter the business. She went in the store, picked out 2 small bottles of Fireball whiskey and a 6-pack of Cider Boys Caramel Apple Hard Cider. Took it to the front counter. The clerk did not ask the CS for identification. The CS was given official Anne Arundel County funds and was able to purchase the Fireball whiskey and Cider Boys Caramel Apple Hard Cider from the clerk. CS exited business and immediately turned over the alcoholic beverages to us directly outside the door. We know through our training, knowledge, and experience that Fireball whiskey and Cider Boys Caramel Apple Hard Cider are both alcoholic beverages. We entered the store, identified ourselves as police officers, identified the clerk as Paul Patel from 10/22/67. He was advised of the violation. He advised that he has been working at the store for 2 years and was alcohol awareness trained. He advised that he was on the manager's agreement with the liquor board. There were no other employees in the store. I observed while I was there, a cup of open container of an alcoholic beverage on the counter next to the cash register. Observed the open bottle of Cooper Peachtree liquor next to it. I asked the clerk if he was drinking the alcoholic beverages while he was working. He advised no, that was being used for samples. The Anne Arundel County liquor license was displayed properly on the wall. A photograph was taken of Mr. Patel, and of the license, photograph was taken of the Fireball whiskey and the Cider Boys Caramel Apple Hard Cider, and it was subsequently destroyed. Photos are in the report. The clerk was cooperative. The store was not busy at the time of the sale, and that would be my statement of facts.
I have no questions for the officer.
Commissioners, any questions?
No questions.
Ma'am, do you have any questions?
I have no questions. I would just be heard in mitigation.
Case is yours.
Thank you, members of the board and Mr. Chairman. Obviously, none of us want to be here for these kinds of violations, and we're here tonight on the 3 separate violations. The first 2, of course, for the sale to an underage individual, And the third is for ownership and operation. That's Chapter 4, Section 3.01D. If I may be heard on that violation first, very briefly.
Please.
So these licensees obtained this license. It was transferred to them when they purchased the business about a little over a year ago in October of 2024. Mr. Vipul Patel, and I may just refer to everybody by their first names because it's a lot of Patels. I apologize for the lack of professionalism, but I just want to keep it straight for the board. So Mr. Vipul Patel was working at the business premises when the new licensees took over. He continued his employment, transferring it to the new business. He was not originally on the management agreement, but when the new licensees went to do their renewal in February of last year, they believed that they did renew the management agreement, submit new paperwork to put Mr. Vipul Patel onto the management agreement. Unfortunately, it was not followed up, and that was never confirmed. So my clients would testify, and I hope the board will accept my proffer, that they believed that Mr. Vipul Patel was on the management agreement. It was only when this violation occurred that they realized that that had not been officially approved by the board. Obviously, we accept that it was not approved previously, but that very next day, the licensees did submit the formal application, confirmed it was approved, and I know the board is in possession of the official approval on November 18th, so very shortly after the incident date that we're here for. Now, in terms of the first two violations and Mr. Vipul, as I said, he'd been working at this business at this point for about 2 years, and he has no prior violations with this premises. He's also been working in the industry for over 20 years, and I'd like to present to the board several letters of commendation that Mr. Vipul Patel had received from the Howard County Department of Police when he was working in Howard County for many years, all of which indicate that he is dedicated to ensuring that there are no sales to underage individuals, and thanking him for his service on, I believe it's 6 different occasions for making sure that underage sales are not taking place. He also assisted in a fraudulent inducement scheme capture. So these 6, I think it's 6 letters of recommendation or commendation, excuse me, from Howard County Police Department just indicate to the board the long history that Mr. Vipul Patel has as somebody who cares very deeply about his job and this industry, and making sure that underage individuals are not able to access alcoholic beverages. Of course, we are here very contrite as to this one incident. I would proffer to the board that Mr. Vipul Patel will testify that the young lady came in and seemed very knowledgeable, and he thought that she was a regular, and that is why he did not card her in this instance. He recognizes that that is absolutely the wrong approach. Even if somebody seems knowledgeable, it doesn't matter what they are asking about. They should be carded if they appear young enough, as this one probably did. The business premises has in place requirements for all of the employees to be alcohol awareness certified. They all are. Of course, Mr. Vipul is also alcohol awareness certified. As you can see from the management agreement confirmation, his certificate is good through 2028. The premises also has the acute POS system, which requires them to scan an ID to make sure that somebody purchasing the product is of age. There's an override, of course, but only for managers, which Mr. Vipul is, because now he's on the management agreement. So the licensees in this instance, we're very apologetic, but take this responsibility very seriously, and have put in place everything that we can in order to ensure that this board's rules and regulations, and of course the laws of the state of Maryland, are followed moving forward. And we would ask the court to accept, or excuse me, the board to accept our contrition and be lenient in your decision this evening. And we are here for any questions.
Chairman, any questions?
The clerk in this case, Mr. Patel.
Yes, he's present.
Was he working at the time of the violation back in December of 2024?
No, Mr. Chairman. Tushar Patel was working at that time. He's one of the licensee.
Okay, thank you. No further questions.
Commissioners, any questions?
No questions.
Okay, anything you'd like to say in closing before we render a decision?
No, sir, thank you.
I appreciate the concern, the apologies, and so forth, but this is the second sale to minor within a year. Last one was December 22nd, 2024. At that rate, you're not going to have a license long. So what I'd like to do, I'm going to make a motion. I'm going to make the motion that we find you guilty of both charges as far as the minors and the sale of under. And normally when we have two within a 5-year period, the fine is $1,000 in each of those two charges. So that's going to be my motion. As far as the ownership and operation charge, I'm going to make a motion for a $100 fine, and I'm going to dismiss the alcohol awareness program charge.
That charge, I believe, has already been withdrawn.
Okay, well, comes out to the same conclusion. You don't have to worry about it.
Great, thank you.
Yes.
That's why I didn't address it.
No, I had it, but I just figured I'd clarify it, so you don't have to worry about it. All right? So my motion is guilty on 3 charges, total of $1,100, no, I'm sorry, $2,100 in fines and cost. Looking for a second.
I second.
I have a second. All in favor?
Aye.
All right, so be it. Thank you very much.
All right, our next case will be for McQueen Lucker LLC, trading as McQueen Bar and Grill. Wantu Digunan, member, authorized person, Inspector Scott Montaigne.
One moment.
Yes, I'm sorry.
Would you like to take the other case that it should be brief?
That would be great.
Wonderful.
Sir, if you could briefly step back and we'll handle the next case.
Just have a seat. We'll be right with you.
Cantina Mama Lucia.
Gotcha. All right, so the next case will be Cantina Mama Lucia, Ricky Hanover, Inc., Narav Patel, President, Inspector Jeremy Fisher. One restriction on the license.
Do you waive
placed-
reading, Mr. Bruce?
Waive reading, yes.
Thank you. Anyone wishing to testify for or against the case before to remain standing and raise your right hand? Thank you. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? I do. Please be seated. Starting from my left, can you please state your name and address for the record?
Yes, Bruce Kovahay, 614 Bosley Avenue, attorney on behalf of the licensee, the applicant rather, excuse me.
Thank you. Sir?
Narav Patel, 507 Hartley Way, Bel Air, Maryland, 21014.
Thank you. Mr. Erdl?
Mr. Kovahay, you may proffer.
Certainly, if the board allows.
Sure. Go ahead.
So we're here in an application, excuse me, for an in-location transfer of a Class H restaurant license with the additions of adding an entertainment permit and addition of liquor. The current license did not have an allowance of liquor. We're requesting addition of that. With regard to the issues, obviously the board's aware that the only issue is fitness of the applicant. And I'll provide some background to Mr. Patel to show that we believe he is in fact a fit and proper person to have the license in this matter. Mr. Patel is 44 years old. He's a Harford County resident. He's been in the restaurant and retail business for approximately 20 years. He's run Dunkin' Donuts franchises, 7-Eleven franchises. He's currently the owner of CR Wings, which is a bar and restaurant in Harford County. That business has been open since 1995. He's been the owner since early 2022. That's an on-sale license in Harford County, and is a successful business to continue to grow under his ownership. He's the sole stockholder of the appellant corporation, Ricky Hanover, Inc. The location, Cantina Mama Lucia, is it's an Italian restaurant located in the Hanover area in the Commons Corporate Center. It's somewhat of a family operation in terms of the clientele and the nature of the business. And Mr. Patel intends to maintain the existing operation with minimal changes. Those two, as indicated, are the proposed changes to add liquor to the license. The intent being just to primarily provide table service to allow patrons to have a selection of cocktails with their dinners and things of that sort. It's not expected to be any significant bar service, but primarily table service, and wants to add TVs to the establishment, which is what requires the live entertainment permit. And so that's the notion for that request. Mr. Patel has already been involved with the current licensee in getting up to speed with the operation of the business for several months, and that has been without incident, has gone smoothly. It's expected this would be essentially a seamless transition if the application is approved because of his familiarity with the business, and would note there have been no incidents, no violations of any nature during the course of that operation. The application, as you'll note, does include, there was one prior service of underage patrons violation at the CR Wings property in Harford County. Subsequent to that violation, Mr. Patel has instituted a number of policies with that business that he intends to carry over to the Cantina Mama Lucia to ensure prevent any kind of repeat of that violation. For example, all patrons are to be carded regardless of age. So if I at age 58 walk in, it's expected I'm going to be carded. 2 employees are expected to verify all purchases, and if reasonably practical, that should include a manager, unless the manager is otherwise detained dealing with other issues in the business, but otherwise the expectations a manager would approve all sales and review the card, the ID, as well as the point of sale person, and that all primary employees, managers, and the like will be alcohol trained and certified. And Mr. Patel has brought with him certifications for himself and a number of employees, if you would require me to pass that forward. I just pass this forward. Thank you. And thank you. Mr. Patel indicated, I confirmed with him that all the information on the application remains accurate at this point in time. Financially, as indicated on the application, he's making a $380,000 personal contribution to the business, of which $190,000 has been funded in cash to date, and the remainder is available in business checking and by line of credit, so that the business remains well capitalized and is in a position to continue its current path. Business is strong and should remain strong. Again, as indicated, as the board is aware, the sole issue to be considered is the fitness of the applicant. Mr. Patel is a longstanding businessman, a longtime area resident with experience already in businesses of this nature. The business is indicated well capitalized, and to the extent there's any red mark or any red flag on his history, that I believe that's been very well dealt with regard to the policies instituted at the other business that he intends to carry forward into the Cantina Mama Lucia, and we believe that that he's a fit and proper person for the maintenance of the license, and we request that this application be approved.
Mr. Chairman, any questions?
I do have a few questions. I think you stated in your statement, rather, you said something about he plans on carding everybody.
Yes.
Well, I'm a frequent patron, so we'll see.
Take a good look. So.
Don't forget this face.
Yes.
The questions that I have is one in reference to his participation with any other liquor establishment in the state of Maryland at present. Are you on any license, or are you involved in any?
Yes, sir, I am. I'm on the license for CR Wings. It's in Harford County, Maryland.
Okay, is that the only one?
That is correct.
Okay. Thank you. And I believe you also testified through your attorney that all of your employees are going to be alcohol awareness trained. Is that correct?
Yes, that is correct. Currently, the only 3 individuals that are not, their duties are dishwashing, back of the house operations. all of the front of the house employees are trained for alcohol awareness program.
Okay, thank you. I have no further questions.
Commissioners, any questions?
No questions from me.
Anything in summation before I make a motion?
I think in summation, again, the only issue to be considered is the fitness of the applicant, and I think even with the one blip on the radar, I think Mr. Patel is certainly more than capable and fit to have to hold an alcoholic beverage license in this county, and the transfer should be approved.
Okay, very well, thank you. There's presently a restriction on this license. Are you aware of that? That's all right. I'll explain it to you. There is a restriction on the license, and it basically says alcoholic beverages must be served with the conjunction of a meal. That means that the only people that can be served alcohol, beer, wine, or liquor, if we approve it, must be in conjunction with the meal. They just can't come in and sit down and have a drink and not order a meal. You understand that?
I understand and acknowledge that.
Okay. I'm going to go ahead and make a motion, excuse me, make a motion that we approve this transfer and the adding of the liquor, but I'm also going to add another restriction, and you're pretty much doing it, so it shouldn't affect you too much. And that restriction is going to read as follows. All individuals involved in the sale of alcoholic beverage shall successfully complete the training in a state-approved alcohol awareness program within 30 days. Now, we have restrictions out there for other licenses that they can't even work one day unless they have that. With the restaurants, we're giving this restriction, but we're giving you 30 days to make sure every one of your employees, once they're hired, is alcohol awareness trained. Waitresses, waiters, it doesn't involve your, bus boys in the back or anything like that, but everybody else must be. All right, that's my motion. Looking for a second.
I second the motion.
I have a second. All in favor?
Aye.
Okay, very good, sir. Congratulations. Lots of luck.
Thank you so much.
Thank you very much.
Thank you, gentlemen.
Have a good evening.
Likewise, thank you.
Our next case is for McQueen Lucker LLC, trading as McQueen Bar and Grill. Would you like to waive reading? Thank you. Anyone wishing to testify for or against, please come forward, remain standing, and raise your right hand. If you want to swear in, that's fine. Raise your right hand. Thank you, sir. Do you solemnly swear and affirm under the penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. You can state your name and address for the record.
Name is Mouto Degueno. Address is 15526 Simmonsbury Way, Upper Marlboro.
Thank you, sir. Mr. Ertl.
Counsel, if you'd like to proffer?
Good evening again, members of the board. Kelly Kylis on behalf of the licensee. We are here on an application for increased privilege. My client is requesting that the board issue a full entertainment permit, including / in addition to dancing.
I'm sorry, say that again. I missed the last part of it.
So my client is asking for an increased privilege to add on or to upgrade the license to full entertainment and dancing.
And dancing?
And dancing.
D&D? Okay. I didn't know that was... Excuse me for 1 second. Okay, there's been some confusion, I believe. All of our paperwork is showing the application for an upgrade to full entertainment or entertainment, but that doesn't include dancing. We have 4 tiers of entertainment. We have music, and we have no permit at all. Then we have music, then we have the entertainment permit, and then we have dancing. I'm going to ask a couple questions, but I have a feeling we're going to probably have to postpone this. But my questions would be something to consider. In this establishment, is he going to have an area that is dedicated to dancing? In other words, a dance floor?
No, so that is, and if you look at the, this is a very small restaurant, as the board may be
Right.
familiar. And so if I may be heard, because I do think there was some confusion when my client submitted the application for full entertainment, he believed that that included dancing. And so under the circumstances of what we're asking for, the board might understand why we're asking for it this way. So as the board knows, we just requested and obtained this new license just a year ago for Mr. Deguinan to open this new restaurant. They just opened back in July. There have been no issues, no violations whatsoever to the license, no problems with the neighbors, no problems with the police. And Mr. Deguinan is trying to expand business, trying to attract more customers, and also trying to give the current customers what they're asking for. Specifically, the current customers are asking to do things like host private events, such as birthday parties, bridal showers, holiday parties, some corporate events. And these events would just kind of be a cordoned off section of the restaurant where they could have some music, have their event, and potentially be up and dancing around the tables. But this would not be like a nightclub style. This is not a major dance floor. It's just all part of having some of these larger events. And by large events, I'm really only talking about 20 to 30 people. The total restaurant capacity is 92. So we're not talking about a massive, raging kind of event. As further, evidence and explanation for what the licensee is asking for, I have for the board an example of a solo acoustic guitarist that we're looking to have come in. This, if I may pass to the board, this is one of the music acts that the licensee would like to have come in to provide some entertainment for the customers, hopefully to attract some more customers. And as you can see, we're asking for something that will continue the upscale but reserved, mature aesthetic that the restaurant is currently exhibiting.
So Council, if I may, my apologies. The live entertainment rules are something we're working on legislatively to clarify because they are notoriously confusing. We have kind of cheat sheets and diagrams that we use to verify what's being asked for, what's not. It's tripped me up before I was counsel for the board. If dancing is part of the request has to be for a dancing permit. I believe under our proposed legislation, I believe a full entertainment permit, which is the proposed language, would include dancing. Under the current permit, an entertainment permit specifically, explicitly denies dancing. I think that the board would be happy to postpone this to be re-advertised if dancing is what they would like. But under an entertainment permit, which has been applied for, no dancing would be permitted. We could certainly try to bring you back in January, depending on the timeline, if that was something, and that would not require a new application, just a letter to re-advertise. If you want a moment.
May we have a brief moment?
Just to clarify, this is something we're trying to clarify. It's our understanding that if the legislation that we've proposed were passed, and we're supposed to have a discussion about it as soon as this hearing is over, part of that is that this would change, this would automatically, if passed by the legislature, become that full entertainment, which would include dancing. My understanding is there would be an additional charge under this permit if we came back in a month. It'd be a $400, I believe, $400 a year permit versus $300 a year permit. Dancing would be included on kind of the third tier in July, in theory, if the legislation is passed. So they
Okay.
could,
That must have been where some of the confusion.
a lot of confusion with these. So for the moment, if dancing was something that was very important, we would want to possibly postpone this and come back, and then we would re-advertise the matter, and then it would be approved as a kind of tier 4 permit. If you didn't, you could go forward at the kind of tier 3 entertainment permit, which, again, if legislation changed, dancing would become a part of that, because it's not a permanent dance fixture.
I apologize for my ignorance, but would it be
Currently,
an
dancing is
automatic-
prohibited under the current legislation, under the tier 3 entertainment. Under the new proposed legislation, the tier 3, which is an entertainment permit, would be considered a full entertainment permit and would allow you to have periodic dancing, but not a permanent dance floor. Correct. We're trying to clarify the language legislatively, because it's a mess.
Yeah, we're trying to allow some dancing to take place in some of these establishments without saying, you know, you have to have the full-scale dancing permit. It's very confusing. We understand. We're trying to simplify that. We're going in front of the Maryland State Legislature to do that. But I think Mr. Hurdle made his point, and that is to get full entertainment is one thing. It won't give them the right to have dancing. But once the law changes, then he'd fall right into that.
Okay, if I may just make sure we're
Please.
all on the same page.
Mm-hmm.
We could postpone the matter until next month for
Mhm.
both and full entertainment and dancing as one option. Would it be, if we went forward with
You just get a dancing permit, is what you would get next month,
next
presumably.
month, which would include full
Includes
entertainment?
everything.
Okay, which I think is probably what my client attempted to ask for this time around.
Again, it's confusing, yes.
Right,
And it's legislatively defined, it's not board rules, just to be clear. We're trying to
Yes.
change the legislation so that it's clear for everyone.
Now, if we went forward, just so that
Today.
we're clear on all the options.
You
if we
get
went
an
forward today
entertainment
on
permit.
On the entertainment permit, and the legislation is changed, would we automatically,
You'd automatically get periodic dancing as part of that.
as part of it? And it would morph, and is that taking place within the next,
July 1st was when that legislation would go into effect if passed.
okay, so if we got the full entertainment
And-
permit tonight, we wouldn't get automatic dancing until July?
And I believe the concern is there's proximity concerns as well with the dancing permit, potentially.
Have to be, there's a 1,000-foot wall that comes into play with dancing. Are you and your client aware of that?
Yes, he did. See, that is where I think I think what he really wanted to apply for
Was a
tonight
dancing
was the dancing permit. Is there any way that the board, given the confusion of these circumstances, could morph today's request from a full entertainment permit to a dancing permit? We did submit, or my client did submit with his
1,000 foot
application, the maps showing that there are no schools or places of worship within 1,000 feet.
Okay.
So
So we do meet all of the criteria for a dancing permit.
it just wasn't advertised as such, which is the concern from our perspective at the moment.
Okay. So one more
Please.
moment. Okay. We would like to postpone the matter to re-advertise
For dancing.
for dancing.
Could you also send a letter to the office indicating that request so there's a formal request in the file?
That was going to be my next question. It's just a letter, not a full application.
Correct. Correct,
Yes.
right? It would
Is
just
that
be a
right?
letter.
Yeah.
Correct.
An amendment.
A letter to amend the application.
We're doing this all on the
We'll
fly,
have it
sorry.
before the end of the week.
Thank you. And sir, we do apologize. Again, this is a mistake that I think happens a lot with even attorneys that we deal with in this matter.
don't you have that, why don't you ask her to call the office tomorrow and discuss it with Eddie in detail? Eddie? Can she call you tomorrow and, yeah? Why don't you just recommend
They're
that?
just trying to figure out what they're doing.
Yep.
It's-
So the request is to postpone at this time.
Request is to postpone and
Commissioners-
reset for January.
I'm sorry. That's, and Janet, we can put this on the January. Wonderful.
Thank
Commissioners,
you.
did you grant the postponement? Yes. It's,
All right. I'm going to make a motion that we just postpone this case until the next hearing, which is January 13th. Okay? All in favor? I need a second first. I have a second. All in favor?
Aye.
Aye. So done. Thank you. Sorry about the confusion.
Thank you, members of the board. Have
All
a
right,
nice
ladies.
holiday.
Ladies and gentlemen, this concludes the hearing for tonight. We are having a town hall meeting. I don't know if anybody is here and would like to speak. Are you here in reference to the town hall meeting? Okay. Well, we're going to take a 5-minute break. All right. And then after 5 minutes, we'll be back here and it'll be your floor in some form or fashion.
All right.
Gentlemen, if you want to come down front.
Yes, if you want to come down front, because if you have any questions, you'll need the microphone. We're really excited you're here.
Yes, thank you.
Thank you for showing up.
And anyone else on live stream.
That's right. Anybody on live stream? So we're here today to introduce the five. Can you hear me? The five legislative bills we're introducing to hopefully get them passed. And so we're just going to go over them quickly so you can understand what we're asking for. So I'm going to go ahead and start. My name is Janet Gagnon. I am the administrator here at the Liquor Board. We have Ed Aronson is our executive director, and Michelle Monty Barnett and Lanalia Caceres as our secretary. So we're here. We are the ones that, answer your questions and do the administrative work in the county or for the Liquor Board. Okay. So the first one we're going to do is renaming entertainment permit tiers.
Per the last case.
Per the last case, they are very confusing, and we're just going to streamline them, modernize them somewhat, and they're going to, the listed new tiers are background entertainment, general entertainment, and full entertainment. The background entertainment will include unlimited televisions to this tier. This is an addition to what we currently have. Having this, we have them in the second. We have to put them in the second tier if you want to just have unlimited televisions, and it's kind of restrictive and more costly. So we're actually including them into the first tier, if approved. So they'll fall into the first tier, and we'll adjust those people administratively if this comes to pass, basically. The full entertainment, which would be the third tier, we're renaming it because currently it's called dancing, and as we just saw, that it can cause confusion. So we want to take out the word dancing, include it as just full entertainment, and it would mean any legal forms of entertainment. So, Eddie, you have some suggestions regarding that?
No, it caused a lot of confusion. We had some establishments, for example, the Soccer Dome. They were a sports facility, and they needed any legal form of entertainment. The third tier, which allowed that, was called dancing. So They were scratching their head, why do I have to get this permit? So that's why we are renaming these tiers, make them a little more modern. So our licensees don't think that when they have a DJ and a karaoke for musicians that they can have, what do you call it?
Spontaneous
dancing.
dancing around tables or what have you.
Right, it's just the last tier would be for any legal form of entertainment, kind of like a venue with a permanent stage, permanent dance floor, floor shows, things like that.
Okay. So you're going to discuss the new license classes.
Yes, so we are proposing 2 new classes. One would be the golf club. Currently, we have a special golf and country club license. This license requires membership, regular or championship golf course with at least 9 holes, 2 tennis courts, and a 30 by 80 foot swimming pool. So we have about 6 establishments that were not able to qualify for this license because they didn't have the tennis courts or the swimming pools. So they had to get another license. They were forced to apply for a restaurant or tavern license, which requires them to operate by rules never intended for their primary business. So we at least have 6 that could convert. It would be a license specifically for them, and they wouldn't have to follow the same type of rules that a tavern or a restaurant, because if that's the class of license they have, that's how they have to operate. So back when they applied, we didn't have anything for them, so they were issued that. So the other one is the sports activity facility. We have a lot of establishments, like I said, Soccer Dome. We have gyms, we have bowling alleys, medieval times. Let's see, we have currently over 15 establishments, businesses that are operating today under a license that simply does not fit their core model. Most were forced to apply for a restaurant or tavern license, which requires them to operate by those rules. Therefore, we're creating these license classes that allow these existing models as well as future businesses to operate under appropriate rules that match their business model. We're following the same footsteps that we took to create for example, the salon license, the gift basket license, and the movie theater license. So these would be particular to that business model. They would have a license of their own. We're in the process of drafting the legislation, but like for you, a bowling alley, that would include, on premise only, 6 to 2 a.m., but you wouldn't be required to sell more food versus alcohol like they do with a restaurant license. And if you had a D license, only 21 or over could be there without an adult. So this would limit you to be able to have your business as you intend, and for your patrons to enjoy how you intended it. So we're doing these 2. We know that we have a need for it, and we've even had people calling us about pickleball. And right now we don't have anything. We could give them a D, but they couldn't allow people under 21 of age. So that would be the 2 proposed golf license. You can leave us your name if you have any input when we do draft the bill. We can give you updates. But I think it's going to be really nice. And we're thinking about the fee for a beer, wine, and liquor license would be $1,200 versus $1,600. That is because Sundays will be included and your entertainment would be included as well. So it's going to save a lot of our licensees a little bit of money and allow them to operate as they should.
Do you have any questions?
No, so this is proposal. Next license would stay. Springtime, your license would remain the same.
Correct.
So it would be in 2027 that your license would be.
Well, let's see. It would go into effect in 26.
Arguably,
Yeah.
you could apply July 1st. We
Yeah.
have a hearing presumably
And we're
August.
Right, and we're going to allow these current existing licenses to go ahead and convert without having to spend time and money going to a hearing. Because they've already been approved for this certain type of license, so we're gonna help them out a little bit and make it come to fruition a lot quicker.
Right, try to morph you in
Mhm.
some administratively.
That would, so in this case, if that license was approved, or that license, there would be no need.
Correct, it would be included, as well Sunday sales, which is normally a separate, both of those are normally separate if you have a restaurant or a tavern. You got it. We're excited.
Okay. All right, Michelle, you're going to go over the one-day licenses for larger events. Oh,
Yes.
turn on your.
Yes, thank you, Janet. So what I'm going to be discussing is the one-day liquor licenses, which applies only to the general public. It doesn't really affect our licensees. But with that said, so the proposed change is to the fee structure for the one-day events. The current system charges a flat $25 for beer and wine and $50 for beer, wine, and liquor, no matter how many vendors or concessions sell alcohol. Under the new proposal, there would be a $25, $50 fee for every point of sale or location that serves alcohol at the event. Any event with 500 plus people, this number is in line with the county's special event permitting, by the way. Proposed fee, if the event, such as like a fair, concert, festival, carnivals, events like that, has multiple like beer trucks or points of sale, a bar, whatever, it's those specific vendors are the ones that's going to get charged the $25 or the $50. The purpose, the reasoning why we're doing this is for resource allocation and safety compliance. Large events require multiple inspectors on site to ensure compliance. And it also, the adjusted fees will directly fund necessary tools specifically for ID checking software. And this is obviously to prevent underage drinking and ensure safety at these large-scale public events. Now, this is different than what our licensees are accustomed to, which is the special outdoor events that they request. They'll submit an application for a special permit for that one day or that weekend. Those are applications that get submitted. It's reviewed by our chief. There is no fee for our licensees to request a special event. So I just want to make sure that there's a clear distinction between the one-day liquor licenses that the general public request and then the special outdoor event request that our licensees request. Our chief might have some more input regarding the benefit to restructuring these fees.
Yeah, very, very quickly. I mean, these fees are kind of just to cover our resources. Some of these events are quite large in nature and draw a significant amount of persons all consuming alcohol. So it's important that we're able to allocate resources to make sure everything is monitored and being done safely and effectively. So, thank you.
And if I could just add, this is only going to affect basically 1% of our one-day licenses. Nothing's going to change with them.
Right.
They're for birthdays, anniversaries, concierges. This is just for, we do about 1,650 per year. This would be about 20 events. And it wouldn't even affect, it'll only affect a few because some of those events just have one or two vendors. This is for the events that have like 6,000, 5,000, 4,000 people with, 10, 12 points of sale where they're serving alcohol. So it's going to affect a very limited, but we feel it's proper because it does take up a lot of liquor board resources concerning the administration with the approving and looking over the license as well as the inspectors. I just want to add that it doesn't affect the
Normal every day, just like you said, the events
large
over
event.
500 or more will be, and they're the one days for nonprofit organizations, and
Stay
they'll
still
still
the
the
same.
same. Okay. All right, so moving forward, our next category is the chief inspector position and change of classification. And we're going to have Mr. Hurdle introduce this bill for us. Oh,
I lost my paperwork. The inspector salaries and board member salary and chief, am I doing just chief inspector? Or all
we're doing
salaries?
the chief inspector position, this one.
So our fourth bill was the chief inspector position, which is changing from an NR5 to an NR15. The concern here is when researching and looking at other counties of a similar size that have a chief inspector position, we found that our chief inspector salary runs about half of what they do in other counties. Our chief inspector is so much more than a chief inspector at the liquor board. They also do any number of things to help out with staff. We also found that other classifications in the office start at an NR13, whereas again, the chief inspector's position was an NR5, which seemed unreasonable. And the goal is to get our chief inspector's position in line with other counties, which is a fair and accurate amount of pay for the amount of work that is put in and the skill that's required. In addition, it would ensure the long-term retention of chief inspectors as opposed to a situation where we would end up being likely a training ground for a year or two for chief inspectors going forward, where they would work for us on a temporary basis and then likely be snatched away by Prince George's or Montgomery or any other number of counties where the salary classification is significantly higher. Again, the amount of work that goes into this, managing our numerous part-time inspectors, is significant, and we think it's certainly a fair change that is in line with the position. Any questions from the crowd? Seeing significant support.
Just so you know, originally when the full-time chief's position came up, and that was me, we had a hard time selling it both in the Senate and the House. I mean, we really did. And make a really long story as short as I can, they wanted the chief's full-time salary to be $30,000 a year. Really? Yeah, really. I mean, this was led by a couple particular delegates, but at the same time, the Senate, they said, well, no, that's not realistic. But what they ended up doing, and to be honest, I didn't raise too much objection because I was the point of subject for that chief's position, because money, I don't want to sound, money was not the object as far as I was concerned. And I was willing to take a lower salary just to get the position to be a full-time chief's position. And unfortunately, that worked for me. And then when it was time and I was appointed chairman, I was lucky. I had a deputy chief, Jim, who was in a similar position to me. The salary was not the most important thing. He wanted to do it. He felt he could add a lot of improvements, which we all know he did. And he accepted it with the understanding that we would try to increase it. And we tried, and it failed. And Jim left us. He said it wasn't the only reason he left, but he left us. I was fortunate. I knew somebody who I knew I was totally confident would make a terrific chief. And I just wasn't so sure I could sell him on the fact that he was going to come over here and no reflection on our staff, but make much, much less than our secretaries to begin with. And the only thing, and I didn't promise them the gold rainbow at the end of the rainbow, but I did tell them we would try. And again, now we didn't fail last year because we withdrew that bill. We took it back. We said, no, don't vote on it. Because if they would have voted on it and failed or agreed to some ridiculous thing like an NR7, that would have hurt us because we'd have a hard time coming back this year and do something. And that's why we didn't do that. So, excuse me, I just wanted to give you some insight into that.
and I think it's important to note that I think it's great that we've got the research that we have now, which may not have been present in years past, which I think has provided a lot of clarity for both delegates and senators, and therefore, from the response we've had, it's been eye-opening that information. It isn't just a salary request for the sake of a salary request. And at this point, my understanding, Dwayne, is that it isn't necessarily going to result in an increase immediately, but there is a potential for growth, which I think is the important part here, is that instead of being locked at the NR5 position, there's a possibility of growth long-term, which is the goal. And again, I think that research that's been provided, I think provides a lot of insight that wasn't present in years past, which I think the delegates certainly, it's beneficial that they did the work they did to get us the chief position. And now that we have the research, I think that they've all been very responsive and everyone's been very open and aware to the difficulties that it creates with the limitation that we have.
Thank you, Abe. I would also like to reiterate that this is a range. It is a range in salary. It's not something that's going to go immediately, giving this position a top end of the spectrum. It is a range. And also to note that our funds, we are not raising taxes, we are not raising fees. Our funds that we have here in the liquor board will pay for this increase. It's not going to raise anybody's liquor fees, license fees, or anything. It is something that we can do within our own budget. So the next would be the board member salaries and proposed increases. Abe, you want to take that one as well?
Absolutely.
Thank you.
We reviewed other areas where we felt that the salaries weren't necessarily respective or hadn't been changed in some time. And we noticed that the inspectors had last received an increase in 2020, and we were hoping to increase that as well. We basically took a 3% average per year, which I believe is below the inflation the last 5 or 6 years, and added 18%. Again, if it was 3% every year, it would compound. So this is technically on the low end of an 18% increase or a 3% per year increase. The goal would be to increase inspector salary from roughly $7,000 today to $8,260 going forward. The deputy chief would see an increase of $1,620 annually. In addition, while doing that review, we found that the commissioners hadn't seen an increase in, I believe it's 18 years. And the chairman's salary, the goal would be to increase it, again, 18% total, and then also to tie the inspectors and the commissioners' salaries to a county-issued COLA. So each year it would adjust by whatever the county gives to its standard employees. If it's 2%, it would be a 2% raise. If it's 3%, it'd be 3. If it's 1, it would be 1. But it would adjust automatically going forward. Going back to the commissioners, the chair would receive an increase of 18%, which would be a $3,240 increase, and the commissioners would see an increase of about $2,700. The goal here is that we don't want to have to come back every 18 years. In coming back every 18 years, we think there's questions as to why there weren't raises. We think that every year we'd have to come back in order to get something that amounts to not a pay decrease by asking for the COLA or the tied to inflation increase. And we think these are reasonable increases. We think that our inspectors do really good work. We think they work very hard. And we think that to not get a raise on an annual basis, even if it's just tied to the cost of living, is something that amounts to effectively a pay decrease on an annual basis, which we think is not the best way to encourage people to work as hard as you guys do.
Yeah, and if I may?
Please.
This is something we've all wanted to do over the years, and timing was never right. You know how that is. But this increase for the inspectors, especially the inspectors, I think is well-deserved. It's 18%, which sounds like a lot, but that's over the fact that it's 6 years since you've had your last one, or a little less. But nevertheless, I think the most important thing is if this passes the way we're writing it, and if it's accepted the way we intend, every year you'll be able to get what we call the COLA increase, meaning every year you'll get a raise. That raise may be 3.5%, whatever all the other county employees get, you're going to get COLA-wise. So I think that's really good because inflation is just killing us all. We know that, and that includes you. And I can speak for myself, and I think almost everybody here when I say you guys are really, really appreciated. We know what you do for what little you've been paid. And hopefully we can fix that. And that's the intent. Okay, thank you.
And once again, we can reiterate that that is something that we can in-house, again, afford in our budget. It won't be going out for taxes. We're not raising license fees. It is something that we can furnish and pay for. So we're not looking for any increases on our fees at this time. And so that's it. So there are the 5 legislative proposals that we have out there. If you're listening and on Arundel TV or whatever, and you have any questions, please feel free to email them to our lqinfo@aacounty.org. We will go ahead and send out to our licensees our town hall meeting. What was this? Our agenda that we prepared for today. So we will send that out to our licensees in an email blast. But I guess thank you, and that's it.
We'll put it up on our website.
Does anybody have any questions?
I was just gonna say, we put it up on the website so anyone can view it.
Anybody have any questions?
Does any, yeah.
Feel free.
Nope. Okay, that's it. We're closed. We're done. Thank you so much, everyone.
We appreciate it.